What's up, everybody? It's been quite a day today, but we made it here. Okay, and that's what I'm excited about. We've made it here to talk through this together. I knew all this was happening today, and I knew the schedule that I had packed in this morning was going to make it so difficult to do everything. And I tried to have it set up to go on with JB earlier today. It just didn't work out for a million different reasons that frustrated the crap out of me, all on my end, none on JB's end. So I texted him again and then was able to just get on there now, which is why we pushed the video back, because I wanted to go on there. I told him I would. I felt terrible about missing out on it. So hopefully you guys were able to check that out and watch the streams on WFLA now. He's great. And so I wanted to, of course, come hang with you guys, dig in, discuss what we saw and what we learned today. So I'll only have time during this video. We're going to watch the arraignment together. We're going to break down everything we saw, everything we hear, and what it means, how the timelines work, answer all your questions as far as it goes to the arraignment. And then tonight, we're going to do a 2 live crew tonight. Okay, 8:45, our old time where, we've hung out and broken down so many trials together, and followed so many trials, daily recaps, whatever it may be. We are going to be breaking it down again tonight at 8:45. We're going to be talking about the motion hearings for the motions to compel, the gag order stuff, because to me, we really learned a lot about the judge, about this case, and about how he views all of that in his comments during those scheduling hearings. So that'll be tonight. But this video, we are going to focus in on the arraignment. And Abby, hey, you know what's great is YouTube leaves it up. And I know it's tough. I hate missing out on anybody that wants to come join in, which is why I'm glad today I'm doing 2. So you and everybody that can hang out with the afternoon crew gets to come hang here for a while. And then if you're available at night, you can come hang back. I don't have the rest of the afternoon, unfortunately, to go through everything, but I'm glad to hang with you now live, Abby, and then on the rewatch crew later. So what we're going to do now is I'm just going to queue up the arraignment. I will pause it. Most of you have probably watched it already by now. I will pause it as we go through, as things happen, to explain what's happening, why it's happening, why they would be doing something like this. And make sure you hit that like button as well if you haven't already, and subscribe and hit the reminder bell, because stuff happens, stuff happens, and we don't always get live or get on the video exactly when I plan to or exactly when I want to. So let's get to the arraignment here.
All rise. Thank you very much. Please be seated. Good morning, everybody.
There are some pauses where things don't happen, so there'll be some dead time, but
okay, let's
here we
get
go.
on the record, please. Thank you. Okay, we are now on the record in State of Idaho versus Brian C. Kohberger, CR 29222803. Mr. Kohberger is in the courtroom along with his attorney, Ms. Taylor. I believe also part of the team is Jay Longston and Elisa Massa, who is participating by Zoom, I believe. The state is represented by Mr. Thompson, Lake County Prosecutor's Office, or Prosecuting Attorney. Ms. Jennings is of that office too, Lake County Prosecutor's Office. Also, part of that team is Ingrid Beatty and Jeff Nye, both from the Idaho Attorney General's Office. I'm John Judge. If you don't know me, I'm a Latah County District Judge, and I'll be presiding over this case. So, Mr. Kohberger, you've already heard a lot of what I'm going to tell you at your initial appearance, but I'll repeat it to you because it's important, and I want to remind you of these issues. So I'll briefly cover your rights, the charges against you, and the maximum penalties if you are found guilty or if you plead guilty. So I'm going to start with the rights. You have a constitutional right to have an attorney represent you throughout these proceedings. If you cannot afford to hire a lawyer, then one is appointed at public expense. Ms. Taylor and her team have already been appointed, so that's taken care of. You have a right to a speedy and public jury trial where the state would be required to prove every element of each charge against you beyond a reasonable doubt. At that trial, you would have the right to cross-examine the witnesses called against you. That means to see, hear, and question them, to call witnesses to testify for you, and if you choose to testify in your own defense. But you're not required to testify because you also have a right of silence. That right is protected under the Idaho and federal constitutions, so you can remain silent throughout these court proceedings, and that can't be held against you. What you do need to remember, though, is that anything you do say, other than to your lawyers, could be used against you in a later court proceeding.
And all this is really important in the context that everybody knows he decides to stay silent and the judge enters a not guilty plea, right? So all this is important, not supposed to be held against him, his silence, because anything he says and the way that he says it can and will be held against you. Now, he does say some things throughout this, so we'll keep an eye on that, but let's remember that. And we will absolutely talk about standing silent or a mute plea or different things that you can call it, him not saying anything that is legally a not guilty plea. But I think it's also really important to point out real quick, why does the judge explain to him all of his rights? Okay. And one thing is important because some of you may think it's a waste of time. Some of you may think I already know this because, you follow this stuff and understand this stuff. But what you also know by following these cases in the media is that there are bad lawyers. There are lawyers that lie to clients. There are lawyers that dupe clients. There are lawyers that don't care about clients and don't talk to their clients and don't explain their rights. So the judge needs to make sure the client understands his rights. And that's why the judge is explaining all of Brian Kohberger's rights at this point and the rights that will follow him throughout this case. And it's important that he understands them. And he will be able to notice, hopefully, if a lawyer is violating one of those rights or is pushing him to violate one of those rights. And we also don't want there to ever be a situation where he says, nobody ever told me that. Nobody ever told me I had the right to remain silent. Nobody ever told me what the prosecution's burden of proof was. We know Brian Kohberger has some criminology experience and research, but the point is, Brian Kohberger needs to know what his rights are so that the process can move appropriately and fairly. And that's why we do this. I just thought that was to shed some light and importance on what's happening here, that we don't just glaze over while he's explaining his rights.
You understand that?
Yes, I do.
Okay, thank you. You also have a right to...
And he audibly answers that he understands that these are his rights, which I think is important.
To appeal any final decision of the court. In order to exercise that right, you need to file a notice of appeal within 42 days of that final decision, or that right is waived. Also, if you are not a United States citizen, any finding of guilt in this state could have adverse consequences to your legal status. Do you understand these rights?
Yes.
Any questions about the rights?
No.
All right. So let's go to the indictment. You have a copy of the indictment in front of you?
Yes.
Thank you. And you see in the heading your name there. Is that your correctly spelled complete name?
Yes, it is.
So anybody that followed the Daryl Brooks trial knows what arguments that could make go away, since he's now admitted on the record that that is his correctly spelled and it's his name. The reason they do that is they don't want that to become an issue later. They don't want to have the wrong spelling of somebody else that spells it Kohberger, as I've seen people spell it accidentally. But it's like, you don't want it. You want to make sure there's no typos, nothing that they're going to try to use as a clerical error that ends up turning into a reason for an appeal or to throw out the case once there's no statute of limitations, but things like that have popped up in the past. So now, to make it easier, they ask right up front, do you see anything, any issues with that? Is that your name? Good. Let's move on. So we don't have to talk about that again. So that's one of the reasons why they do that.
Is that the correct birth date underneath your name?
Yes.
Are those the correct last 4 digits of your social security number?
Yes.
Thank you. All right, I'm going to read you the charges on the indictment, starting with count 1, burglary. That is a felony under Idaho Code Section 18-1401 and 1403. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did unlawfully enter a residence located at 1122 King Road, Moscow, with the intent to commit the felony crime of murder.
So again, I've seen some discussion about what a burglary is, and whether he had to steal something, and obviously not, or whether it was just entering the house unlawfully, and it's not. It's entering the house unlawfully without permission with the intent to commit a felony therein. And we know we're about to hear the 4 felonies that he intended to commit when he entered the house, allegedly, right? But that's the crime of burglary. You enter the dwelling with the intent to commit a felony. And here they're saying he entered their residence with the intent to commit these 4 felonies.
Count 2, murder in the first degree. That was a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. Count 3, murder in the first degree, a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Kayla Gonzalez, a human being, by stabbing Kayla Gonzalez, from which she died. Count 4, murder in the first degree. That's a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. Alleging that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Zaina Kernodal. Excuse me. This is hard. I'm sorry. Dana.
So let's take a quick second, because I've also heard a lot of talk about this, where he stumbles over the name a little bit. Then he said, this is hard. And I heard a lot of people say, was he saying this is hard because he couldn't read the names, because the names were hard? Zaina Kernodal, not the easiest name to say. Gonsalves, not the easiest name to say. I messed it up the first time I said it. I mess up stuff all the time and mispronounce stuff all the time. So no, I give the judge all the grace in the world where it comes to pronouncing all these names and reading these documents with all this pressure and public eye and everything like that. But I also heard a lot of people say that he said this is hard because we're talking about 4 young lives that were lost. And I think that's a possibility as well. Just that it's a sad situation. It's a sad set of circumstances, a sad set of facts. And I think that the judge is a human being entitled to his emotions, and that would be okay as well. I also think a judge is very capable of thinking it is a sad factual scenario without believing that the criminal defendant over there is guilty before he has his day in court. So just because the judge is saying this is a sad scenario does not mean he thinks Brian Kohberger did it. Okay. And I just wanted to kind of throw that out there. I see a bunch of people coming in from Emily D. Baker. Welcome, all the law nerds. Thanks for joining us.
Zainab Kernodal, a human being, by stabbing Zainab Kernodal, from which she died. Count 5, murder in the first degree. This is a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing Ethan Chapin, from which he died. This is signed on May 16, 2023, by the presiding grand juror. So now I'm going to go to the maximum penalties of each charge.
So those are the charges: burglary and multiple murder charges. Now he's going to go to the maximum penalties. And the reason for this, again, is so Brian Kohberger can understand this is what he's charged with. This is what he's facing. This is what he's looking at. This is the minimum. This is the maximum. We, in this country, I think this is really good for people to watch. And I'm glad. That's the point about these cases. I don't think we should sensationalize these cases. I don't think we should convict people in the court of public opinion. I don't think we should jump to conclusions. I don't think we should speculate and pull stuff and act like it's fact and like we know this is what happened or that's what happened. But I think it's incredibly important and educational to watch and understand that some criminal defendants are like, I didn't know this happened. I didn't even know what I was charged with. I had no idea I could ever face this much time in prison. That's why we have this. That's why every defendant has a right to this arraignment where the judge, not he can say, oh, my public defender didn't tell me this, or my criminal defense lawyer didn't tell me this, or the state said this, or whatever. A judge explains this stuff to the criminal defendant to make sure they know what it is, because we as a country have decided to do it that way in the legal system. Is it perfect? No, far from it. But when we see a problem, we try in the legal community to fix it and to make sure nobody's getting railroaded or bamboozled, that he understands, at least from this point of view and at this point in time, what he is facing. And that's important.
Starting with count 1, burglary, minimum 1 year, up to 10 years in imprisonment, fine of up to $50,000 or both fine and imprisonment, restitution for.
So he's looking at from 1 to 10 years for the burglary, which is the least severe crime.
For the victim's economic losses resulting from the crime. For counts 2, 3, 4, and 5, murder in the first degree, maximum penalties, life in prison, or the death penalty. Fine of up to $50,000 for both fine and life in prison or the death penalty. Restitution for the victim's economic losses resulting from the crime. Also, additional fine of up to $5,000 to be paid directly to the victim's families. If you are found guilty or plead guilty on each charge, and the maximum sentences are imposed consecutively, that means one right after the other, you could be facing 10 years in prison, followed by 4 consecutive life sentences or death penalties, fines of up to $200,000 and $20,000 to be paid directly to the families with any restitution resulting from the crimes.
Important also for the judge to point out, you could be looking at 10 years plus 4 consecutive life sentences. That's the max. Now, we know you only got one life here on earth. So 4 consecutive life sentences, it is what it is. It doesn't actually exist. You can't be in prison for life sentences, but you have to make sure they understand the maximum, that they don't think, well, maybe 10 years means life, or maybe life means to age 75, or maybe if we combine these together, it can only be 10 years. No, none of those questions. 10 years plus 4 life sentences is what you're looking at.
Okay. Kohberger, do you understand the charge in count one?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count two, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count three, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count four, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count five, murder in the
Yes.
first degree? Do you understand the maximum penalty?
Yes.
And Ms. Taylor, is Mr. Kohberger prepared to plead to these charges?
Your Honor, we will be standing silent.
All right, so I'm going to back that up because we're going to talk about it. It went through kind of quickly, but I know a lot of people have questions about this. But first, I want to talk about the fact that Brian Kohberger said, yes, he understands the charges against him and the potential penalties he's looking at. Okay? So that's a really important part. And then I'm going to put this up on the screen. And Bothwell, greetings. Can I ask, standing silent, why automatically not guilty? I guess I've watched too many TV trials, but this is news to us. Okay? So with this question in mind, we're going to watch again what happens, how it happens, and then we're going to talk about standing silent.
To plead to these charges? And Ms. Taylor, is Mr. Kohberger prepared to plead to these charges?
Your Honor, we will be standing silent.
And because Mr. Kohberger is standing silent, I'm going to enter not guilty pleas on each charge. Counts 1, 2, 3, 4, and 5.
All right. So there you had it. This is what most people were talking about today. What does it mean to stand silent? Why stand silent? Why not just plead not guilty? To me, this was an intentional decision by Brian Kohberger and his counsel. And while it could be a nothing burger, because basically standing silent, legally speaking, is the same thing as a not guilty plea. That's why you saw the judge enter a not guilty plea for all of the counts. And this goes into what we just heard, the judge explaining Brian Kohberger's rights, including the right to remain silent. That's going to be at this hearing and every other hearing and every other time Brian Kohberger, anything happens to him in this case. Of course, it sounds like my camera just died again. Really great. Really going to have to figure this out. But when we talk about standing silent, okay, and we talk about why somebody would stand silent. Number one, they do not want anything they say to be held against them. So what that means is, I hear people saying I froze. It was just my camera. Sorry. Eventually, maybe we'll be able to figure out the technical difficulties, but this is exactly what the issue was with JB earlier. It's so miserable. It literally makes steam come out of my ears and my blood boil, but we're going to bypass that for now and say, you heard him say anything can be held against him. So when we talk about saying not guilty, pleading not guilty, if he would have said, not guilty, I am not guilty, I did not do this, and pound the table, people would have an opinion about that. Number two, if he would have said not guilty softly or bashfully or nervously, people would say, well, why did he do that? Why was he too nervous? Why was he so bashful about it? Does that mean that he did it? And to me, there is something behind that. And that's why I do think it is a chance that this was on the advice of counsel. So instead, he stands in silence, which again, as I already mentioned, legally speaking, is in fact the same thing as pleading not guilty. And when we talk about pleading guilty or pleading not guilty, a lot of people change their plea later, right? A lot of people start out with a not guilty plea and eventually change it to a guilty plea. And that could happen in this case. But because they intentionally stood in silence instead of pleading, I don't think it's unfair to say, why? Why did they do this? And I think the main answer might be they don't want people to take it and run with it. I think another reasonable explanation, I mean, people are saying BTK did it. He took that professor. We know there's at least some sort of potential connection there. Also, maybe he's working with the state as far as a potential guilty plea, and admitting what you did is part of it. Taking responsibility is a part of guilty pleas all the time. And maybe all of this is leading to one of the other questions we got here, which is, Aaron, when will we know if it's a death penalty case? Well, the arraignment starts the trigger, which is 60 days from the arraignment the state has to file their notice of intent to seek the death penalty. So they have 60 days, and if they do seek the death penalty, that could be a bargaining chip. Or maybe they won't seek the death penalty because they're already working on a plea deal, and that's why he is standing in silence as opposed to saying not guilty. Maybe the state said it would make the victims' families feel better if you don't stand there and say not guilty. I think there's a very small chance of that being the reason why, but it's a non-zero chance. I think the main reason why is he didn't want the media or anybody to run with the way, the fashion, the speed, or the power in which he said not guilty. That would be my guess if you just want my guess.
Now, at this juncture, the state has 60 days to get a notice of intention to seek the death penalty. And Mr. Kohberger has a constitutional and statutory right to a speedy trial. So let's start with you, Ms. Taylor, and then Mr. Thompson to discuss scheduling.
Your Honor, we'd ask the court to set this trial at the very outside of the speedy trial, right? We're not prepared to do anything but ask the court to do that today.
Okay.
All right. So I also heard some people asking, did she say that the judge is going to set this outside the speedy trial period? And the answer is no. She said near the outside of the speedy trial period, because as most of us can count by now, we know that that's 6 months that he has to have a speedy trial. And October puts us right at 5 months, a little less than 5 months, because I think they said October 2nd. So we're talking about 5 months away or less than 5 months away. If you set it there, it's still well within his speedy trial. She mentions the word speedy trial without waiving speedy trial, which I also think is important because that is a conscious decision to not waive speedy trial. And that is incredibly important because if the defendant waives speedy trial, you can't get that back. And if you waive speedy trial, that's how these cases sometimes end up happening 3, 4, 5 years down the road. And everything gets more difficult if you wait that long. So the fact that they did not waive the speedy trial, I think is important. And the fact that everybody kind of agreed to the date where they're at is also important because, and the state is about to agree to that because making it happen in October is still enough time that allows everybody to work on the case, prepare for the case, deal with discovery issues, and still prepare for trial. And we're also talking about a situation where they waived his right to a speedy preliminary hearing, which allowed a couple months to go by where they could do discovery and they can learn things and get terabytes and thousands of documents. Because they were able to do that, plus these 5-ish months now, that gives them a lot more time than if he was indicted by the grand jury immediately and they demanded speedy trial and they set the speedy trial within 6 months. That, I think, is a different ballgame. But as we sit here now, I do think there is a chance, even if it's a small chance, I do think that there is a chance that they do demand speedy trial and this trial does happen within 6 months. Because the difference between this case and a lot of other cases is the period of time between when he was arrested and the preliminary hearing that was not is months that they used to gather discovery, go through it, come up with their defenses, interview witnesses and potential victims. They're going to order the grand jury transcript. So they're going to get to know what the state presented to the grand jury. And they've had all that time and still yet another 5 months. So it's a lot more than just the 6-month normal speedy trial period. So that's why I put the chances somewhere up 5 or 10% chance when I was on JB's earlier that this trial actually happens October 2nd of 2023, which again leaves 95% chance that I think something happens to delay the case. The defendant eventually waives his right to a speedy trial, and we have a trial somewhere down the road. But I don't think this is one that's going to stick around for 3 or 4 years. I think everybody's going to work to make this trial happen because the media continues to fight the gag orders. A lot of things are going on, a lot of public interest. The victims' families are pushing the case as well with lawyers of their own. Nobody wants us to sit around for 4, 5, 6 years with delayed justice because people say delayed justice is no justice at all. So he didn't waive speedy trial. They set the trial period right at the end of that deadline, right before we get to 6 months, which may give us just a little bit of wiggle room. If they need to continue the case 1 month, they'll be able to do that. But anything outside of that, he's going to have to waive a speedy trial. And this case will take place sometime probably in 2024. But we'll see. I thought that was interesting that they did want to kind of push it to that end of the time period.
Counted out, and that would be November.
I have not counted it out, Your Honor, but I believe that would be about November 22nd is when it's run. Maybe November 2nd is when it's run. Maybe November 2nd.
So basically the judge, and they were talking about when is the end of the speedy trial period. I just backed it up so I could hear it again. And they said about November 22nd. So again, November 22nd, as crazy as it is, I think it's right around, I don't remember. I think is that the date of the crimes? I think I know it was November 20 something. So 6 months from now is that November 22nd date, which is the speedy trial date. That's when they have to have this trial done by. That the time period has to end. It is 60 days from the arraignment, Deborah. They have 60 days from the arraignment for the death penalty. 6 months to try the case.
So I'd ask the court to set it for an October trial date.
November 13th, somebody said. Yes, thank you. Yeah, November 13th for the crime. So it's just 9 days after the crimes were committed, a year later.
My best guess is it would take at least 4 weeks, maybe 6.
All right, and that was just a quick tidbit there. So how long does the defense think this trial is going to take? And Bodie asked, why did the judge ask the defense lawyer how long she thought the trial would last when the prosecution has the burden? That's a great question. He could have asked either. And most of the time, lawyers get together and discuss how long a trial is going to take. How many witnesses do you have on the state? How many witnesses do you have on the defense, if you call any witnesses at all? And they come to an agreement about how long this is going to take. So we talked a little bit about whether or not we thought the defense maybe knew the grand jury proceeding was coming, and they maybe knew the preliminary hearing was not going to happen at a certain point, and they started working together with the state. This would indicate they have discussed how long they believe the trial is going to take with the state. And it's somewhere between 4 to 6 weeks. If you ask the defense attorney and the state basically agrees, but a lot can happen in the next 6 months. So the judge isn't going to hold them to that. The reason the judge asks how long is because he has to put it on the trial docket. So if it's going to be a 6-week trial and he only says 1 week for trial and then he's got something else on week 2, that's not going to work. If he thinks it's going to be a 4-week trial and then, November 2nd, he puts a trial that date, that's not going to work. You've got to make sure you give ample time to have this case tried within the speedy trial period, because you don't want the judge's calendar creating an issue and now violating potentially the defendant's rights to a speedy trial. So that's why the judge has to ask how long this trial is going to take. And that's probably Bodie who asked the question, why they asked the defense, because if you say you need 4 to 6 weeks and then, when we get close to trial time, you say I need 3 months. Well, now the defense maybe created this issue. And while they're not going to hold them to this 4 to 6 weeks, the judge asks to make sure we can get this done within the speedy trial period, which is also why he asked, when is the speedy trial period? And she said about November 22nd. All of this stuff is really important to protect throughout the entire process of a criminal trial. And that's why the judge is asking the criminal defense attorney most of these questions. And you won't hear a lot of argument from the state because they know they have a duty and a burden to prove this case beyond a reasonable doubt within the speedy trial period. That's the whole point of speedy trial.
So you'd like me to set this for a 6-week trial?
At this point, I would.
Well, and in order to do so, I will have to get rid of some of the other 30 trials I have, but this is more critical and more important. So, Mr. Thompson, what's your?
Those trial dates are workable to the state judge.
Thank you.
He knows he can't argue it's got to be after November 22nd. He wants to get this trial done too. They're probably more prepared at the defense. I don't think that's a stretch to say at this point. So he's not going to argue with that date. That works. Thank you, Heather.
About October 2nd, starting.
Yes, Judge.
Okay, for 6 weeks.
Yes, sir.
Anything else we need to address today, Taylor?
Not with regard to this trial setting.
Anything else?
No.
Thank you. Mr. Thompson?
Nothing to say at this time now.
All right. So with that, by the way, I do want to let everybody know, if they don't already know this, that once the grand jury issued the indictment, preliminary hearing scheduled to start on June 26th was no longer needed and is vacated. So some people are confused about that. So I thank counsel and the media and the public for your attention and respect. So we are adjourned. Thank you.
So that was the end of this hearing. Raven is correct. The gag order hearing, gag order hearing was also today. The gag order hearing was not. The arguments were not done. The motions were not done. They scheduled when they were going to do that. They also scheduled when they were going to handle the motions to compel with the discovery issues. Those were both set in June. One, I believe, on June 9th, was it? Yeah, June 9th and June 27th. June 9th is the gag order arguments. June 27th is the motion to compel arguments. A lot more on that tonight. We're going to watch that hearing together and break down what we learned from the judge and which way he's tipping his hand. 8:45 p.m. tonight, we're doing 2 lives on this because I want to answer questions specifically that you have around arraignment and this process and where we go from here. So, Mehdi, isn't killed and murdered the same thing? Why does he have to name both things when naming the charge? So there can be lawful killings, but murder is the unlawful killing. So that's why a lot of times they're not used synonymously. John, will this judge also be the trial judge? There's a good chance of that, yes, but things can happen. I don't know if he's going to retire. I don't know if they're going to rotate judges. I don't know if he's going to, get taken off the case because there's some kind of bias and he gets disqualified. So all that could happen. But as it sits right now, the way it's set up is, yes, this would be the judge that also sits there for trial. He's the district court judge. Azam, Peter, arraignment and preliminary are the processes that take place before trial, right? What is the difference between them? Thanks. So the preliminary hearing is kind of like a mini trial where they would have shown all the evidence they have against Brian Kohberger, why he probably committed this crime and that a crime was probably committed. proving probable cause is what they would have to do at the preliminary hearing. That's gone now because the grand jury indicted him. But regardless, the arraignment is when he has read the charges that are coming against him that the grand jury indicted him for. This is where he's explained what his rights are throughout this process, and he's explained what the possible punishments are. That's what we just watched together. The arraignment is kind of the chance for him to know and understand what's happening. Pooh Bear, hey, Peter, do the families have any influence on the state pursuing the death penalty? So most of the time, the state will talk to the victims' families, and they will get their input. Do you want the death penalty? Do you not? Why? What types of things would make you feel okay if you didn't? Would you rather guarantee a conviction for life or take the chance and go for the death penalty? Law RN also asks a similar question. Does each family need to agree to take the death penalty off the table to offer a plea deal? So the answer to that is no. So they will get the inputs from the families, and they want the families to all be on the same page, and they want the families to all agree. But at the end of the day, it is ultimately up to the state as to whether or not they intend to seek the death penalty in this case. They have to figure out if they think they can prove it. They have to balance what it's going to be like throughout the process, like in Lori Vallow's case and even Murdoch's case. They took it off the table. The judge did in one case and the state did in the other, because the process is a lot more laborious, a lot more difficult. It can create other challenges. So ultimately, it is up to the state. Bianca, question: if standing silent and pleading not guilty is effectively the same, why does standing silent exist? Again, because the defendant has a right to remain silent, and saying not guilty is potentially an admission, or is a statement that can potentially be used against him in the future. So we do allow in our country defendants to stand silent and not say anything that can be potentially held against them. And it effectively is a not guilty plea. Terry, huge if, standing silent was because he may plead guilty down the line. Why all the seeking of the state's evidence from the defense attorneys? Because they're doing their due diligence. They're zealously defending their client. They are protecting his rights. And we don't know that that's the case. But many times, even if a client is going to plead guilty eventually, they want to know what evidence the state has, because as horrible as this may sound, it does happen sometimes where the defendant thinks, after seeing all the state's evidence, there's no way they can prove this case, so I'm not going to plead guilty anymore. Sometimes that does happen. Jacob, I think this will be a death penalty case, as Ms. Taylor, the public defender, has brought in a second lawyer to help with his defense. I agree. I think the state will seek the death penalty in this case. It may be used as a bargaining chip in plea negotiations, or it may just be what they're seeking. I definitely would be surprised if they just said, no, we're not going to seek the death penalty in this case. Angel, do you take cases in West Virginia? And if so, how do we contact you? So email me at lawyeryouknow@gmail.com. Tragoslaw.com is our firm website. We handle certain cases there, like car accident, wrongful death cases, but not every kind of case. SW 4x4 Explorers, if BK had an alibi, would that be known? Also, would it be known if he worked alone? I don't know how we would know if he worked alone at this point, but if he does have an alibi, he has to let the state know that he intends to produce an alibi as his defense. And if he has any witnesses as to what his alibi is, the state would have the opportunity to depose those people, know who those people are, and understand that that's the defense he's going to be bringing. J-Dubs, could standing silent be strategic because the defense doesn't have the evidence the prosecution has? I mean, it could be strategic for a number of reasons, but I think at the end of the day, it is a not guilty plea. So right now, he is not admitting that he did this. He is not pleading guilty, and that's basically all we know. We don't know the motive for standing silent from his team or from Brian Kohberger at this point. We don't know if it was the advice of counsel or if Kohberger himself refused to say that. We just don't know a whole lot more than what we're watching. Pepper, did they mention the deadline for discovery to be turned over to the defense? I don't think so, because the state and the defense are still going to be arguing about that on June 27th. Tori, late night lives are back. Yes. At least tonight they are. Azam. So the arraignment still happens whether it's prelim or grand jury. Do I understand this correctly? Yes. You still have to be arraigned on the charges. He still would have had the charges explained to him that this is what the judge found probable cause on. Here are the charges. Here are the potential punishments, the maximum, the minimum punishments for these charges. Here is what you're looking at, and here are your rights. That still would have happened even with the preliminary hearing. April Diaz, just wishing you a great afternoon. Thank you, April. And I want to take a second because tonight we're going to do more Kohberger. Thursday is going to be an incredibly fun members only live that is going to be different than anything we've ever done. John is still working on it now. We've already filmed part of it. I'm incredibly excited. I think it's going to be fun. It's not law related. So none of the subscribers that are here for legal breakdowns or explanations or education, none of that. You're not going to miss any of that. So don't worry about it. But if you want to come hang out, it is going to be fun. Lexix, thank you for the super sticker. So the preliminary hearing is a great process in the criminal justice system because it explains the rights to the criminal defendant. We want them to go into this with open eyes. And this is where competence is really important. We see it in a lot of cases. We see it sometimes where we think the criminal defendant might be faking competency issues. But this is why competence is important. If you're competent to understand what's going on, we're going to explain to you throughout the process what your rights are and try to protect them. I mean, that is something we've seen, whether it's Daryl Brooks or Alec Murdoch, or this case, or Lori Vallow. The criminal defendant's rights should and will be protected throughout the process, or else there will be a remedy in the law, like an appeal or tossing the charges altogether. So that is going to be incredibly important in every case. So I'm glad we got to watch it together here. And tonight on the stream at 8:45, make sure you subscribe. If you haven't subscribed yet, take a second, subscribe, and hit that reminder bell, because tonight we are going to dive in. We're going to listen to the scheduling conference, and it's not just a, hey, what date do you want to do this? Okay, good. There is a lot more of it in that hearing. And I've got a lot of thoughts on exactly how it went and how the judge is feeling throughout this process, who's pushing for what, and where the judge is leaning. And the judge gives a little insight into how he feels about the Supreme Court's ruling and their opinion that they gave regarding the gag order. M. renewed. Would you have done the same course of action to be silent if this is your client? It's impossible for me to answer because I don't know what Brian Kohberger is saying. But if he told me he didn't do it and we're fighting to prove his innocence, I probably would have advised him to say, I am not guilty. Barbara, that doesn't mean he would have done it, right? Because lawyers can give their advice. What time on Thursday is the members only? I need to put it in my schedule so I don't miss it. We haven't planned that yet. My schedule is crazy. For anybody that doesn't know, still a full practicing lawyer, always will be. Love it too much. A trial lawyer. Most of what I do is civil trials. I've done a lot of criminal trials as well. So scheduling is sometimes difficult, like it was today. Joe, a year. Here's to the next year learning from you. Joe, a valued member. So pumped you're with us a year later. Midwest Girl, why such an early trial? Will there be motions pushed out further? So in Idaho, it's 6 months from the arraignment that you have to have the trial within the defendant's speedy trial rights. That would be around November 22nd. And so they picked October because it was near the end of the speedy trial period, but not the very end. So it gives them a little wiggle room if they need a short continuance to still get it done. Ellen, shout out to Nicole, Azam, and Sunshine for the memberships. Yes, I see just memberships being gifted left and right. And you're going to be thankful this time because it's going to be funny. You're going to get a chance to laugh at me, see me in a different environment, maybe a little more unfiltered, hopefully not too embarrassing or obnoxious, but probably for some of you. So get ready. Brenda, welcome to the crew, and Nancy A. All right. Couple other things because people ask, okay? And that's why I'm saving this till the end. You can sign off if you want. We're done talking and breaking down the arraignment. But I did go on JB WFLA Now today. So if you want to check that out, please do. And let them know in the comments that you came from here. And then number 2, I'm going to go on Megyn Kelly to talk about this Kohberger case on Wednesday. If you happen to watch that, shout it out in the comments. You guys are the best. I have just such a great time talking about this stuff with you guys and this community and people who want to take things too far and not try to be objective and not try to weigh the process and understand the process, I think make it more difficult. And I don't think the judge is going to like that in this case. So I really appreciate that this community and the people that talk about this case here with me on these lives and through these comments, I really appreciate you. And I think that if EDB is on Court TV tonight, check that out as well, please. But if we can continue to do that, and that becomes more of the norm, how the public discusses these cases, I think we will have more access, and I think there will be less restrictive gag orders. That's just a little prelude to what we're going to be talking about tonight. And a couple more, Ghani and Tori, welcome. a new Tory and a Tory that's been around a while. What's the difference between staying mute and saying not guilty? Again, you have to actually say it out loud, not guilty, versus just standing silent or standing mute. So that's the main difference. Same thing as like pleading no contest. There's some similarities with that. Then pleading guilty has the same effect, but there are some minor differences with pleading no contest. Standing mute is basically the same thing as not guilty. Martha and Jackie, welcome as well. A couple members just sliding in here right before we finish. So yeah, check out everywhere. Your favorite people on YouTube are going to be, including Emily D. Baker on Court TV tonight. I appreciate you all so much. I appreciate you so much. I can't overstate that. You guys are the best in dealing with my issues here with the camera and whatever happens. I just know that we're here to learn, to hang out, to talk, and that's always awesome. Cheryl, welcome. If you want to hear a little bit more about what I do besides this YouTube stuff, stick around for the outro. If not, hit the like button on your way out and please subscribe. Until next time. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.